Good afternoon, everyone, and welcome to the LIBER webinar on EU copyright reform and why research libraries should care about it. Thank you very much for joining us today. My name is Friedel Grant. I'm in charge of communications at LIBER. Thank you also for bearing with us through a few issues with sound checks. I think we've got them sorted out now, and hopefully the webinar will run smoothly from this point in. I'll introduce the speakers in a moment, but first I just wanted to go through a few housekeeping notes. The webinar will last about 45 minutes. We are recording the webinar, and we'll share the recording on YouTube and on the LIBER website after the webinar finishes. As participants, your microphones are muted during this webinar, but you can share comments or questions with us via the chat box, and I'll keep an eye on those questions and we'll come back to them after the presentations. With that, I'd like to introduce the speakers that we have today. First, you'll be hearing from Benjamin White. He's a member of our working group on copyright and legal matters. He works for the British Library. He's very active in the intellectual property field. He also chairs the copyright group of the Council for European National Librarians, sits on the UK Intellectual Property Office's Copyright Research Expert Advisory Group, and has spoken as an expert legal witness at the Legal Affairs Committee of the European Parliament. After Ben speaks, we'll be hearing from Helena Lovegrove. She's LIBER's advocacy advisor. She's worked in EU public affairs for nearly 2 decades and has recently focused on cultural heritage interests. And with that, I'm going to hand over to Ben, who will give us an update on how EU copyright reform is currently shaping up. Ben, over to you.
Okay, can you hear me okay? Yes, I think that's working. I'll assume it is. Well, yep. Okay, good. Good afternoon, everyone. As Friedel said, I sit on the LIBER Legal Working Group, where we deal with a number of different issues from the perspective of research libraries, from copyright through to data protection, as well as licensing, and particularly in regards to kind of open access, of course. So today what we're going to be talking about is probably or definitely the largest change to the European copyright law framework. So it'll be the largest change since the introduction of the current Information Society Directive or Copyright Directive, which dates back to 2001. And this is important because it will shape what kind of services libraries can undertake and provide to their users, as well as what kind of activities libraries themselves can perform. I'm sure many of you are familiar with the basics of copyright law, which create a system where, while a work is still in copyright, there are what are called exclusive rights, so rights which the rights holders can control exclusively, and then you have what are called limitations and exceptions to those exclusive rights. And those exceptions may or may not require remuneration, but they don't require permission, so they can often make the work of a library a lot easier when dealing with a lot of content or multiple different content contributors, because you simply don't have to get permission, which obviously causes can cause has a a time and cost repercussion. Sorry, my voice is going. So yeah, why should libraries care? Well, libraries should care because, as I said, it does affect how and what services libraries can provide to their readers and their users. So the current proposal, which is called the Digital Single Market Directive, dates back to the end of 2016, where the European Commission put forward its draft proposal. As of the week before last, the European Council, which is made up of all the representatives of all the European Union member states' governments, the European Council, not last Friday, but the Friday before, finalised their view, their draft proposal in response to the European Commission's proposal. So we have a finalised Commission position, we now have a finalised Council position, and jury is expected to, jury being the European Parliament's Legal Affairs Committee, is expected to vote on a parliamentary position later this month. So in terms of process, which Helena will be talking about later, once the European Parliament, the European Council and the European Commission all have a position on the proposed directive, we would expect then in September that trialogue starts, and that's the process where the representatives from the Commission, the Council and the European Parliament sit together and try and come up with a final text which marries the three separate positions. So that's enough from me on process. So what I will do is I will go through not all but some of the parts of the proposed Digital Single Market Directive, and I've picked out those that really relate to libraries, education and research. So the first one is a proposal on text and data mining or data analytics. This is really how you make use of big data by using computers to analyze data. So the Commission proposal from 2016 proposed that the exception to the exclusive rights for this, so the exception should only cover research organizations and educational establishments. So that would exclude certain sorts of libraries. For example, some national libraries are not actually part of an educational establishment, so they would be excluded in the Commission proposal. The proposal was cognizant of the fact that this is about big data and all the economic hype around that. So it allowed public-private partnerships between the beneficiaries and private companies. Very importantly, it did not allow the contracts regarding the subscription of data or, for example, terms and conditions on a website. They didn't allow those contractual terms to negate the actual exception itself. So essentially, irrespective of what terms and conditions or a contract would say, you would still, under this exception, be allowed to do the data analytics. It was a mandatory exception, the proposal, and also it how can I put it? It sort of encouraged rights holders where access is legitimate to give technical access to allow text and data mining, while still obviously preserving their own technical protection measures on their systems. So at the moment, technical protection measures, sometimes called DRMs, digital rights management systems, erroneously, sometimes they prevent electronic access to materials. So the idea of this proposal is not to remove them, because clearly technical protection measures are important to prevent illegal use of digital material, but to encourage rights holders where they knew the source was legitimate to not prevent the technical undertaking of text and data mining. So that was the Commission proposal. Then moving on to the Member States, to Council, they've added all types of libraries as beneficiaries, so not just those linked to an educational establishment or a research organisation. and they've added a new non-mandatory exception for commercial players. However, this new exception would allow contract and technical protection measure override, but it only allows derived derived data to be kept on a temporary basis. So obviously we don't, well, there are various different views on what temporary could or could not mean, but generally the process of data analytics requires quite a lot of investment to normalize data, to aggregate data, to create derived data sets that can be further analyzed. So we have an issue with this proposal coming from Council. If that's how text and data mining works in the real world, and yet you can only keep the results and your derived data sets on a temporary basis, how does this actually work? So I think that's one question, and I apologize, there's a mistake in that slide. It should say only allows derived data to be kept on a temporary basis. Then moving to the European Parliament, and there are different parliamentary committees, and just for ease of simplicity, I've focused on the Legal Affairs Committee, which is the main committee with competence over this directive. So hot off the press, we've just finally seen a proposal coming from the rapporteur, the chief MEP for this directive in that Legal Affairs Committee, has just been made known about a week ago. So as with any draft, it's going to have positives and negatives, and on the positive side, it does allow some commercial use. It again, on the positive side, it doesn't allow contract override if you're an educational establishment or a library, and it weakens the technical protection measures that we discussed earlier. On the less positive side, the proposal is very unclear, very difficult to work out really what is being envisaged by this draft. It doesn't seem to allow public-private partnerships for educational establishment and libraries, but it does allow some commercial use. So again, the lack of clarity means it's quite difficult to work out what's actually going on. And then it basically removes press publications from being subject to data analytics, and okay, sorry, I'm just reading a message from Friedel, but I see it's not aimed at me. So it removes press publications from being subject to analysis by computers, and it also appears to establish a new kind of HTML protocol where you can say, I don't want my website to be analyzed. Which I think is going to create quite a lot of debate. So I'm pretty sure we're taking questions at the end, Friedel. Is that right? Until I get the answer to that, I shall plow on.
We're questions at the end.
So that, yep. Right. So if you've got questions on text and data mining, you're going to have to remember them for a while. Moving on, we have illustration for teaching, which is an existing exception in the European Copyright Directive, and I'm sure exists in most European countries' copyright laws anyway. So there hasn't been huge amounts of change from the original Commission proposal. So it allows an exception for use of an in-copyright work to support your teaching for people on the premises, as well as remotely for educational establishments. So if you're doing distance learning, the exception allows distance learning. Member states can exclude the exercise of this exception where there are licenses available for teaching purposes. And there is an obligation to make those licenses visible, which is, I think, a positive step forward. And then for those of you interested in the mechanics of copyright, it's interesting because it creates a situation where copyright pertains to the upload of or the activity that goes on in the country of upload, to avoid legal issues where there is cross-border access going on here. So the jurisdiction that applies, irrespective of where the students are is the jurisdiction of upload. And again, it sort of weakens the use of technical protection measures, which again would arguably or could undermine the exception. And then I suppose, and it's quite difficult because obviously there are a lot of amendments going on, but perhaps one of the main amendments that we've seen in the Legal Affairs Committee is to ensure that the licenses that are being offered don't actually undermine the exception. So essentially the licenses that are offered have to at least be as good as the exception, if not better. Given that that's the advantage of licensing, that you're dealing with the rights holders, one would assume that this is non-controversial because that's the purpose of the license, that it does essentially improve upon limitations and exceptions. The next article of interest to libraries is a proposal on preservation. So again, it would be a mandatory exception. So all member states would have a exception for preservation, which covers both digital as well as analog works that are in the permanent collection of a library. And then again, as with technical protection measures and as well as illustration for teaching, we see sort of a weakening on the technical protection measures that we see in the InfoSoc directive. And in the recitals in the Commission proposal, there is very quick reference to this going on, preservation activities taking place in a cross-border manner, which the Council has improved upon and made very clear that that the preservation activities can take place across border. So a library in Belgium, for example, could ask a library in France for French language material, or in the Netherlands to preserve something on its behalf, because obviously libraries, museums, archives and galleries, there are hundreds of thousands of them, and they are all very, very different sizes. So smaller cultural heritage institutions are unlikely to be able to do digital preservation. So this is a way of kind of recognizing that fact and allowing, clearly allowing this activity to go on across borders. So the European Parliament draft at the moment adds a new provision that prohibits any new copyright being created when a reproduction is being made for preservation purposes. So I guess it's a bit like the Europeana mantra that what stays in the public domain, what enters the public domain should stay in the public domain. And then again, the jury proposal very clearly allows preservation networks, which is the point really of this proposal, I would argue, and for those networks to work across border. I think real concerns about this in the European Parliament are the recitals currently don't allow materials that are subscribed to on a temporary basis. there's no definition again of what temporary means. Is that I'm temporarily accessing this for 24 hours? Or are libraries' journal subscriptions temporary because they are renegotiated every year or every couple of years? So I think this is something that the library groups at the European level will be seeking clarity on. And then it requires preservation copies to be deleted and returned to the original organisation from where it came. Well, that undermines existing law, where any entity can employ another entity to act on their behalf as an agent. So this is undermining of existing legal principles, not just copyright legal principles, but other legal principles where agents can be employed. And well, it doesn't make much sense either, because if the small organization doesn't have the capability to digitally preserve the material, format, shift, etc., then it doesn't solve the issue, which is organization A doesn't have the capability to do digital preservation. That is why it's asking organization B to do it on its behalf. So this draft, in this sense, really undermines the actual raison d'etre of having this new exception. Articles 7 to 9 deal with out of commerce works, or another way of saying this is in copyright but not commercially available materials that sit in libraries, archives, museums, and galleries. And as everyone will be aware, this became a sort of a headline issue in 2004 with the Google Books project, where although libraries and archives had been putting material online from 1994 and the advent of the open web anyway, it kind of became a political issue and caught the headlines in newspapers globally. So we've sort of been waiting, I would say, as a community since 2004 for a legal way of doing mass digitization in Europe. So this is extremely important for larger research libraries, as it's a way of facilitating our in copyright but commercially available collections going online. So the proposal from the Commission is that licenses for this activity should come from collecting societies. Member states should convene what is called stakeholder dialogue in member states between cultural heritage organisations, collecting societies, rights holders, and government to discuss what licenses might be forthcoming, what could be in the licenses. The draft excludes the works of non-European Economic Area citizens for literary written works and artistic works, which is clearly a problem if you're dealing with collections in English or French or Spanish and Portuguese that are widely spoken outside of Europe. We don't know, is this person American, French Canadian, Senegalese? In some instances, we are very unlikely to actually know the nationality of the rights holders. So in the real world, there are some severe limitations on this. And then it requires central sort of registration of what material you would like to digitize. So the idea is that you would put a list on the European Union's Intellectual Property Office website, and that is a mechanism for rights holders to opt out. No, I don't want my work to be licensed. Thank you very much. So that's a good mechanism to get transparency. What is it you want to digitize? Okay, no, I don't want my work to be used. And then a central point to sort of point rights holders to, because the collecting societies are going to have to do sort of promote the licenses that we're to enter into with them to rights holders themselves. So the council draft sort of makes explicit. I mean, you could argue it's maybe implicit in the commission draft, but the council draft makes explicit that what we're talking about here is both published material or broadcast material, or material played on the radio, but also material that was never commercially available, so our unpublished collections. And then it tries to sort of weaken some of the responsibilities around checking if a work is in commerce or not, because obviously you could end up going to 55 different resources to try and work out whether something is in commerce or not. So it sort of brings in a little bit of common sense around that definition. The European Parliament and the different committees have listened to the argumentation from the library sector and have really updated it to make it clear that this proposal coming from the European Commission will not help where there is no collecting society, because if there's no collecting society, they can't offer a license, or where a license cannot or will not be forthcoming from that collecting society. And that might be because a collecting society exists, but its remit doesn't allow this online use of commercially unavailable materials. So there are a lot of reasons, or a number of reasons, why a collecting society might not be able to offer a license, and therefore the European Parliament has said, okay, well, if there is no license, or there can be no license, then we want to encourage large-scale digitization of European culture and give access to citizens online, and therefore an exception would kick in. The exception may be subject to remuneration, depends on the member state. Again, it would allow opt-out, so the actual mechanisms would be very similar to the license. It's just that it would not come from the collecting society per se. Again, the European Parliament version allows never in commerce works, and there are still those issues that I mentioned earlier with non-European works being used, which if you're dealing with a book, it's kind of, you would not too difficult to work out where somebody, are they European or are they not European. But if you're dealing with films, all the different layers in songs, a magazine, a journal, you're just not going to know, is every single contributor European, yes or no? So getting towards the end of my bit now, so perhaps less central to the works of libraries, but may or may not have some kind of ramification depending on how things end up. There is a new proposal for a new publication right for newspaper organizations. So the argument being that in some member states it's not clear who owns the rights and therefore who can license all the rights in a newspaper. So the proposal from the Commission is this new publication right would last for 20 years. It's not going to affect the rights held by any of the contributors. They will still be able to use their works if they didn't assign it to the newspaper. And it allows also publishers to claim remuneration for limitations and exceptions where rights have been transferred to them from authors. So, for example, public lending right, or other kind of exceptions that relate to the use of authors' works. It explicitly would allow publishers to receive some of that money. The council proposal makes it very clear that the right would not apply to any insubstantial amount. So presumably a couple of words, few words. The right will only last for 1 year, so not the 20 years, and the beneficiaries would just be EU-based news organisations, so not third country newspaper organisations. And then I understand the Legal Affairs Committee is split whether to propose the deletion of this or whether to come up with some sort of proposal. Oops, jumped ahead too much. And right, hopefully we're there. And finally, we have Article 13, which has been written about quite a lot in the blogosphere, which is about online content sharing providers. So these are organizations who host uploaded content at scale, and they require they're being required to work with rights holders to prevent illegal content being made available online. I mean, it doesn't say this, it doesn't require this, but it does mention, for example, filtering technologies. And the proposal also encourages stakeholder dialogue. One of the concerns that we've had about the Commission proposal is universities are organizations who host uploaded content at scale. So are universities caught by this, yes or no? And I think the council version of this might deal with that issue because it explicitly refers to the e-commerce directive. And in there, not perfect, and maybe we would want it better than it is, but in the e-commerce directive, it talks about these organizations, online content sharing providers, information society providers, as they're called, as being organizations which are, or rather, platforms which are hosted for profit. So one would hope that that excludes universities, but universities charge in many countries for you to go to university. So an argument perhaps could be made that even with this cross-reference to the e-commerce directive, institutional repositories of universities could be in scope. Then the legal affairs current draft again is just sort of variation on a theme, really. Requires uploading platforms to get licenses and again prevent upload of content as identified by rights holders. So again, very similar to the Commission proposal. So that's me. Over to Helena.
So can everyone hear me?
Yes.
Am I online?
Yes, you are, Helena.
Okay, good. So thank you and hello everybody. So thanks Ben for taking us through all the content. I will just say a few words about the process and time frame. So let me see if I can move to the next slide. So I don't know how familiar you are all with the EU legislation process, but it is a long process. That's basically what I would like to say. Most legislation goes through something called co-decision procedure, which means that both the European Parliament and the Council will have to agree on a text. So, as you know, the Commission came out with this proposal in September 2016. So we're almost 2 years away from that. It went simultaneously to the two institutions who have to agree, so the Parliament and the Council. They are it starts in smaller working groups or committees where you have experts on the subject, and they discuss and they propose amendments. So as you can see on this slide, we are still at one of the first steps where the Parliament will have to agree on a position. And maybe I will come back maybe to this slide a bit later, but so if everything goes according to plan, we might have a Parliament position in July or September. And then the Council will, then there is a discussion between the Council and the Parliament. It's called trialogue. It's basically informal discussions between these two institutions, and the Commission sits in to be the neutral part and facilitate. And then after that, the text that they agree on goes back to the Parliament plenary, and if it gets backed by the full Parliament, then it also needs to be accepted by the Council. And if the Parliament decides to make some more changes to that final text after the trilogue, then the Council might not want to accept those changes, and then it goes into the second reading. And if you see in the left-hand column where I say first reading, there is no time frame. So these people, they can be allowed to prolong this as long as they like, but of course they try not to do that. But if in this reading the two institutions can't agree, then it goes to a second reading. And in this case, it would be probably somewhere in next spring that will start, and then it's time limited. So the Parliament only has 3 to 4 months to come up with a new proposal. The Council then has 3 to 4 months to work on that text. And then if they can't agree again, then it goes to conciliation, and that is 6 to 8 weeks. And if they can't agree after that, it goes to third reading. And if they can't agree there, then it collapses. It goes back to the Commission. So we don't know what the outcome will be. It's a very controversial proposal on certain articles, especially Article 11 and 13 that Ben presented. And it is possible that there won't be an agreement. But everyone is trying to find some kind of common approach to this. They spent so much time on it. So if I go to the next slide, sorry, we'll see here. This is the schedule that I mentioned. So the Council have given a mandate to the presidency, which is for the moment Bulgaria, and that will be handed over to Austria as of 1st of July. So they have a mandate to discuss with the Parliament. And this week there are 4 meetings scheduled in the Parliament to discuss, to try to finalize the text of this proposal. And on the 11th of June, that is the deadline they've set themselves to finalize the whole proposal in the Parliament. And there will be a vote at the end of June in the Committee of Legal Affairs, which is called Jury. And that will be very interesting. But so the rapporteur, Mr. Voss, if his report is adopted in that committee on the 20th or 21st of June, then it is very likely that it will be also accepted in plenary, so the full Parliament in July or September, which means that Mr. Voss, gets a mandate to discuss with the presidency, as I said, first Bulgaria, but it will be handed over to Austria, so it will be Austria in the autumn, to try to agree on a final text. Then, if they can agree, this will go to have to go through a formal adoption process, and that will happen in the spring 2019. It has to go back to the Parliament plenary, and then it goes to the Council, and there might be changes, as I said, and if there are changes, it might prolong the whole process, and it's impossible to predict exactly what's going to happen right now. But if all goes in best scenario, I mean, that if they agree quickly, then it could be adopted properly in the spring 2019, and then there is you have 2 years of a transposition into national law. So it's only in spring 2021 at the earliest that we'll see this into national law. So let me see what's next. Yes, this was basically to say that we have 2 years of transposition, and then this copyright file won't be reviewed not earlier than 5 years, it says in the directive, but more likely it won't be reviewed before 10 years. Then just a few points. I think key points is that Mr. Voss, who is the rapporteur in jury in Legal Affairs Committee in the Parliament, seems to be supported by the Liberals and the Conservatives. So he will most likely have his report approved. And then in the Council, I think we can go back to this if it's necessary, but I'll take you to the next slide to show you that everything is, of course, needs to get political support. So Voss sits in the Conservative Party, EPP, who has the majority seats in the Parliament, 28.9%. In order to get majority in the voting, he will need support, of course, ideally from the socialists, but they don't always agree. But it looks likely then, as I said, that he is supported by the Liberals, ALDI, they have 9.1%, and then the ECR to the right of EPP, so the Conservatives, 9.9%. This is very often a combination of political groups in the voting. And then the Council, so those who, basically the body that represents the member states. This is just a procedure of how they work towards a position. So to the left, as you see, the Council Working Party. These are the experts who have been working on the file. Then this goes to the ambassadors, who have to agree, and they have just approved or given the presidency a mandate. Not all member states agreed on the text, so we will have to see at the end if it gets enough support to go through. Germany and Belgium, for example, did not agree to the proposed text. But there was enough support to give the current presidency the mandate to start to discuss with the Parliament in the trilogue. And then the last step to the right is the Competitiveness Council, which is composed of ministers from each member state, and they make the final decision on if they want to accept the text as it is. And well, this is just to show you that the Council is composed of, all the 28 member states. And for the moment, oh, sorry, I have Estonia up here, but, so it is Bulgaria. And then it goes over to Austria for 6 months, and then Romania and Finland. So each member state has 6 months presidency. And the member state have a special voting system where you need a qualified majority vote. Basically, you must have 55% of the member states, of the 28 member states, and together they have to represent at least 65% of the EU population. So this is to avoid that, a number of smaller countries could make a decision over bigger countries. So anyway, there is a way of calculating if one believes that something will go through or not. 4 countries can block any proposal if they are big enough to represent 65%, the blocking minority is 35% of the population. And I have put a link in here. I'm sure you will get this presentation. And if you're curious, you can click and play around with it to see which countries could block a proposal. And then I just sort of made a few slides on the advocacy activities we have undertaken, but I don't think necessarily we need to go through this here. I think I will just quickly flick through, and if you have any questions about it, feel free to ask, and you can have a look at this at your ease after this webinar as well. And there are some links here to open letters if you want to read them. But I think what is important to point out is that throughout this process, since the Commission adopted their proposal, is that there are a lot of stakeholders who are lobbying on this file. Not only libraries and cultural heritage institutions, but it's been a lot of publishers of scientific articles, news publishers, book publishers. You have the internet service companies and platforms. You have authors and creators, and consumers, and various cultural heritage institutions. So I think I'll stop there, and if anyone has any questions, I'm happy to answer for this. Now we have 8 minutes left of this webinar. So how can I hear? Because I can only hear myself.
I think you should be able to hear me now, Helena, all being well. Thank you both very much, Ben and Helena, for your excellent presentations. I'd like to open the floor now for any questions that you might have. We had a couple earlier in the webinar. The first one I think was aimed at Ben, asking if web archiving activities, which a large number of national libraries are conducting in Europe to preserve national cultural heritage, could be included in the preservation exception for heritage institutions in the absence of a specific legal basis. Ben, can you give us your thoughts on that?
Yes, I think that's the purpose of Article 5. It's to, or from our perspective anyway, it's to support digital preservation networks, which is obviously how digital preservation works in part in the modern world. It's too difficult, expensive, time-consuming, costly, technical for every organization to digitally preserve its own collections. So we were slightly disappointed with the Commission proposal, which just talks about, in the recital, mentions cross-border issues. So we're very happy that the Council and the European Parliament have understood that it's about networks, including cross-border networks.
Great, thank you. And another question for you. Someone said they didn't quite understand, or it wasn't quite clear for them, why this copyright reform proposal might affect institutional repositories of universities. Can you elaborate on that?
Yes, so this is Article 13. So what Article 13, if you look at the text, is it talks about putting these obligations for getting licenses, ensuring that material, only material for which there is permission, can be uploaded. This talks about this obligation being on information society service providers, which is not defined. which is why the cross-reference to the e-commerce directive is quite interesting. So it's putting obligations on information society service providers, organizations which host content which is uploaded at scale to their platform. That sounds rather like an institutional repository to me, a platform which has content uploaded to it at scale. I think, as I said, the council cross-reference makes it clearer that we would be unlikely to fall within scope. But I think the library and research organisations would welcome an explicit statement which says that educationally oriented information society service providers are excluded. So I think we're certainly not the aim of this legislation. It's aimed at organisations like Facebook and YouTube, but it's all about the core definitions. So when there's a lack of clarity about the definition, you start to wonder, well, are our online content sharing services in scope or not? Which is why the library groups have certainly been saying that there should be within the text explicit reference to exclude educational repositories.
Great, thank you. I'm very aware that we're running close to the hour mark, and it's getting a little long for our normal webinar, so I'll close shortly. But before we do, Ben and Helena, I just wanted to give you a chance to maybe let the people who are listening today know how they can influence the process from here on in, because I know that we do need their help in order to get the message across to the Commission. What would you say to them?
So I would, if there's anyone on here, so one thing we've discussed in the LIBER working group is if we as the LIBER working group were to come up with a standard template to write to their MEP, and we would highlight which MEPs in which countries, if people would like to help in that process, if they could email liber@kb.nl, so the LIBER website, we would like to know who they are. I think we may never ask, or we might ask only once or twice. So if anyone is interested enough to volunteer to write a letter to their MEP, we would very much like to hear from you. Oh, and there we go.
Wonderful. Thank you, everyone, for attending, and also to our speakers today. I'll be sending out a copy of the slides and, of course, the recording as well, probably early tomorrow. And thank you very much.
Thank you.
Thank you.